Item number 1 for the petitioner, my lord. My lord, there is two correction is needed in the order sheet. In the case reference, page number 1, in the place of New Jalpaiguri Police Station, it was written Jalpaiguri Police Station. And page 2, petitioner number 1's name was Hamida Khatun. It was written Rajesh Haq alias Manna.
দেখে নাও এটা করে দাও। Let the order dated April 4, 2025 be corrected by substituting the name of the police station in the cause title as New Jalpaiguri within court instead of Jalpaiguri court, and by correcting the name of the petitioner number 1 as Hamida Khatun instead of Rajesh Haq alias Manna as incorrectly printed. Stop. Let these corrections be incorporated in the order dated such and such.
প্রথমটা বলে দিয়েছে my lord, item number 2 and 10 may be fixed at 12, my lord. I'll be there.
I may not sit till 12 o'clock. Why?
Because, my lord, very honest, my lord, actually my junior has he has left the bag.
Let us see, pass it over. If it comes before I rise,
my lord, definitely.
Before the list gets exhausted.
And for the petitioner, my lords, the alleged charges are against 341, 326, 307, 302 IPC. There's total 6 accused person, my lord. I am one of the abettor or instigator at the best, my lords, and on top of everything, my lordship, a coordinate bench has already granted bail to one of the similarly placed petitioner, my lords, on 10th of April 2025.
The victim died subsequently.
Yes, ma'am. This is the one
302 was added
Before his death, did he record any statement, the victim?
that time.
Postmortem report is 151, and this is the 164 statements file.
Eyewitness?
Yes, ma'am. One 176. Five 164 statement was there.
Victim's wife?
And page 177, 182, 183 are the 164 statement also there.
Where is the name of this petitioner? Tajimuddin Mia?
Name is not.
Where is the name of this petitioner?
Well, 182, 183 also. 177, 182.
You have just shown me 177.
182.
That is the deceased victim's wife.
Yes, my lord.
She doesn't name this petitioner.
No, my lord, 182 and 183.
$182 is 161.
Oh, my lord. Kindly give me the signal. 79. What kind of apartment?
No overt act has been attributed. Charge sheet?
Chashi, submitted, my
Submitted.
lord,
On
17th to 2025 is for production and appearance.
Yes. Total
What-
21 witnesses.
What is the age of your client?
My lordship, age of my client, my lords, is 43 years now.
If I
The petitioner is one out of several accused persons. Stop. He says that he had no intention of harming anybody. Stop. A dispute arose between the accused persons and the victims. Stop. That led to the alleged incident. Stop. A similarly circumstanced accused person by the name of Subhash Chandra Roy has been enlarged on bail by a coordinate bench by an order dated April 10, 2025 in CRM bracket M 30 of 2025. Stop. He says that he will fully cooperate with the police. Stop. Paragraph. Learned State Counsel, while opposing the prayer, draws my attention to the statements of witnesses recorded under section 164 CRPC. Stop. The victim's wife does not name this petitioner. Stop. The deceased victim's wife, call it deceased victim's wife. Stop. However, another witness does take this petitioner's name, but no overt act is attributed to him. Stop. Paragraph. On an overall consideration of the facts and circumstances of the case, and seeing that charge sheet has already been submitted, comma, and also a co-accused person who appears to be similarly circumstanced has been granted bail, comma, I am of the view that immediate custodial interrogation of the petitioner may not be necessary so long as he cooperates with the police. এটা অ্যান্টি বেল কোনটা কোনটা বেল ছিল ও আইসি ও দিস ইজ বেল
that it is
করে দাও তাই
bail. Oh, bail.
বেল It's further custodial detention. Charge sheet has been filed upon completion of investigation. Further custodial detention is not necessary.
Satisfaction to the satisfaction of the additional district and session judge, fast track court, which we have.
Full Lord, kindly make it short, pass over. I'm checking the case diary. Lord. Short pass over.
Lordship, short pass over.
Six time for the petition.
State, pass over.
I am for the state, your lordship.
Short pass over. I'm for the state, Lordship.
My lord, the allegations are under sections 306 and 34 of the Indian Penal Code. Now, the de facto complainant, my lord, had lodged a complaint on 6th of December 2022, wherein, my lord, he has stated that his brother had a love relationship with one Nita Shah. Now, Nita Shah is the daughter of the petitioner numbers 1 and 2 and sister of petitioner numbers 3, 4 and 5 before your lordships. Now, as per the FI written complaint, the love relation was for 5-6 years. Then, my lord, they decided to get married. Before the marriage, my lord, Nita Shah and the petitioners before your lordship, my lord, demanded money from the boy. Allegedly, my lord, a portion of his property and some cash, which he could not give, and my lord committed suicide by hanging.
Nita is not accused.
Nita is also accused. Nita, my lord, was granted anticipatory bail by the learned court. My lord, the order is at page 16.
Yes, madam.
Lordship, 161s are corroborating with the prosecution case, Lordship.
Charge sheet has been filed.
Charge sheet has been filed and postmortem report, which is in page 34, it's non-continuous ligature mark is there, Lordship.
Continuous?
Ligature mark.
Yes, what does that mean?
Lordship,
So the cause of, what is the cause of death?
Nita Shah is on bail.
306 anyway is a very difficult to prove, very weak. Anti-mortem hanging. Pesho. The petitioner,
Petitioners, my lord.
না এরকম ভাবে করো. The charge is under section 306/34 IPC. Stop. The victim who committed suicide, as would appear from the postmortem report, comma, had an affair with Nita, comma, daughter of the petitioner numbers 1 and 2 and sister of the petitioner numbers 3, 4 and 5. Stop. The allegation is that when the victim and the Nita decided to get married, comma, prior to the wedding, comma, Nita and the petitioners demanded money from him. Stop. He was not in a position to pay. Stop. He was humiliated by Nita and the petitioners, which prompted him to kill himself. Stop. Paragraph. I have seen the petitioners say that Nita has been granted anticipatory bail by
the learned Sessions Judge Darjeeling,
Likhecho, by an order dated
10th of August 2023.
23.
Yes, ma'am.
Stop. Charge sheet filed.
Yes, charge sheet.
Stop. They have no complicity in the alleged crime. Stop. They pray for anticipatory bail. Paragraph. Learned State Counsel opposes the prayer. Stop. She says that statements of witnesses recorded under section 161 CRPC corroborate the prosecution case. Stop. She has shown me the statements and the postmortem report. Paragraph. On an overall assessment of the facts and circumstances of the case and the nature of the allegations as well as the quality of materials on record, comma, I am of the opinion that immediate custodial interrogation of the, and considering that charge sheet has already been filed, comma, I am of the opinion that immediate custodial interrogation is not necessary.
Grateful. Satisfaction, ACKM, plea.
Nine.
I'm for the statement.
So allegation under section 147, 148, 149, 142, 186, 353, 420, 427, 323, 322, 379, 435 and 307 of Indian Penal Code. So FIR was registered against two accused persons initially, including the petitioner and one Tapos Sarkar. However, subsequently charge sheet has recently been submitted against 16 accused persons, including the petitioner, and this is the case proceed. The allegation is that when the police was discharging his duty in a particular area, the crowd was gathered, and there was a commotion going between the crowd, and police was also involved into this matter, and his one vehicle has been damaged during that period of transactions. So this is the allegation, and that's why this FIR has been registered.
Is absconding, my lord, his warrant of arrest is pending against him. WA is pending against him.
Does that, no, once warrant WA, simple WA is
Yes.
issued,
There's no bar, but.
There's no bar. when does the bar sit in? When WPA is issued?
WPA is issued.
Offender, when there is a judicial
He,
order of
when he's a
contempt offender.
proclaimed offender.
Proclaimed
The
offender.
Lavesa, there is a judgment, a 2012 judgment of Supreme Court.
So this is the case of?
307, I don't find
307,
307, my
but
lord, but there are photographs, the police vehicle was.
Case of 2013.
Yes,
Yes.
but recently has charge sheet submitted on
Let him
9th of
surrender.
March 2025.
Let him surrender.
Who was injured? Who was injured? Anybody injured?
No.
So police party was, the minor injuries they suffered.
307 is here. Kichu nahi. What? No, I understand. No, but was the policeman, where is the injury report?
Only thing that is absconding in 161 statement, his name, transferred everywhere. He's the very few, he's among those very few who were identified.
What about the others? Other charge sheet, they are. Yeah, last day of circuit. The petitioner says that the FIR was filed in the name of two persons, including the petitioner. Stop. However, charge sheet has been submitted naming 16 persons, including the petitioner. Stop. The incident was that allegedly the accused persons resisted policemen and prevented them and tried to prevent them from discharging their duties. Stop. There was a ruckus. Stop. A motor car was damaged. Stop. Nobody was injured. Stop. The petitioner prays for anticipatory bail. Paragraph. For 12 years, your police could not arrest him for 12 years. Opposing the prayer, learned State Council says that the petitioner is absconding for a long time. Stop. Warrant of arrest is pending against him. However, he fairly admits that there is no specific injury report. Stop. Paragraph, I have considered the material on record.
And my strong objection may be recorded.
Yes. With opposing যেটা বলেছি না, vehemently opposing. ব্লক ক্যাপিটালসে দেবে এই এন্ট্রিটা, বোল্ডে দেবে, আন্ডারলাইন করে দেবে, আইটালিক্স করে দেবে। আচ্ছা, কি বলেছিলাম লাস্ট? Including statements of witnesses recorded under section 161 CRPC. Stop. There are general allegations against this petitioner. Stop. Paragraph, considering the nature and gravity of the offense and the fact that charge sheet has already been submitted, comma, I am inclined to allow the petitioner's prayer for anticipatory bail so long as he cooperates with the police. You see, one of the conditions in all my orders is within 7 days, he'll go and meet the. Yes. He will, if you need further investigation, he'll cooperate. That is there. And once every fortnight, charge sheet to hoye geche. So, IC বা OC meet korbe. Jurisdiction IC OC. And 438 to IC.
Grateful, Lordship.
Then Passover.
Well, I am for the petitioner, my lord. But in this case, my lord, allegation under section. Well, allegation under section 316(2), 316(5), 318(4), and 61 of the BNS Act, my lord, corresponding to section 405, 409, 420, and 120B of the Indian Penal Code, my lord. The petitioner, my lord, allegation, my lord, the main allegation, the shortage of stock. There is a warehouse at the beat para, my lord. The petitioner is a store manager, and one Amit Mahato is the, my lord, cluster manager. My lord, main allegation is that Amit Mahato, on being asked, he could not give satisfactory answer, and he fled away. And my according to me, only me allegation is that I could not give the satisfactory answer. The stock of the warehouse. This is the main allegation.
Yes, you are a manager.
Stock main cluster manager. The main person is cluster manager.
Are you a manager or not?
I'm a stock manager. I am the Milord.
Yes, so you should know more about the stock.
Plus,
What was stored there?
iron rod, Milord.
TMT.
Yes, that is valuable.
60,
Yes.
let's-
Charge sheet submitted.
No, Lordship, investigation is going on, Lordship.
Go and
Because
surrender.
Lord, next circuit.
Huge
Lord,
quantity,
kindly
Lordship,
make next circuit.
discrepancy.
The last day of the circuit, Milord, kindly make it next circuit.
No,
No,
after hearing you, just because I will not pass an order next circuit.
Milord, kindly see the order, Milord. Kindly see the FIR, Milord. Kindly see FIR, Milord. Page number. Like page number 11, Milord.
Yes.
Page number 11, Milord. Third para, last line, Milord. Last line, fourth line. This is my allegation, Milord. Amit Mahat, Milord.
75 metric ton,
Yes, Your Lordship.
valued at 48 lakhs.
Yes, Your
yes,
Lordship.
Lordship.
Milord, the fourth line of responsible for the bid para order, subsequently the action and order that the suspicious behavior upon the questioning, Mr. Amit Mahato displayed suspicious behavior and absconding along with inadequate, Milord. But allegation against me, Milord, explanation from Anirban Ghosh, this petitioner, failed to provide satisfactory explanation for the shortage, Milord.
Yes,
This is the allegation against me.
right.
But I will cooperate the investigation.
No, Lordship.
I will cooperate the investigation. This is 406 matter 420, Milord.
Go and surrender. The petitioner says that he has been falsely implicated. Stop. It is true that he was the manager, store manager. He was the store manager of the concerned warehouse where iron rods were stored. Stop. However, it was the cluster manager, Arun,
Amit Mahato, Milord.
Amit Mahato. Cluster manager Amit Mahato, who should be held responsible for the shortage in the stock of iron rods. Stop. Amit is absconding.
Yes, sir.
Stop. He prays for the petitioner prays for anticipatory bail. Paragraph. I find from the first information report that a shortage of 75.22 metric tons of iron rod valued at approximately rupees 49 lakh is missing from the concerned warehouse. Stop. Investigation is in progress. Stop. Given the nature of the allegation, comma, custodial interrogation of the petitioner may be necessary. Stop. Hence, I am not inclined to allow his prayer for anticipatory bail.
Well, I have got the petition.
Hmm.
The main allegation is under section 109 of BNS corresponding to 307 IPC.
His nature of injury?
Grievous loss.
What was the incident? What happened?
Lord, actually, what happened, my lord, kindly come to page number 14 of my petition, my lord. There is an FIR, my lord.
Statement of the witness, page 9, 10 and 11 verse.
And my lord, kindly see our injury as well. And combination of documents.
X-ray plate.
My lord, yes, the petitioner has been suffered no bone injury even. Actually, what happened, my lord, in page 14, our FIR is there, my lord. There was a scuffling between the neighbors regarding that the de facto complainant of this case is very influential in the locality. I'm coming to that, my lord. He tried to outrage the modesty of the sister of the de facto petitioner, my lord. And out of that reason, that the dispute took place. And my lord, on that occasion, some other persons of that locality also came there, and they also tried to rescue the sister of the petitioner, and also petitioner who was being beaten by the de facto complainant.
In point of time, who lost the FIR first?
My lord,
Manoj
two things.
Mondal.
The de facto complainant was the
Present
FIR. My lord, kindly see my compilation of documents. I went to the Kotwali police station to register my case. Police did not take step. Then, my lord, then and there on 21st, on the next date, I filed the complaint to the SP Jalpaiguri. Despite of that, my lord, there was no action. I was being compelled file a petition before the learned magistrate. Thereafter, under the direction of the learned magistrate, the FIR was registered under 12 POCSO, my lord. And my lord, kindly see my injury reports. On the 20th October, on the date of incident, I was admitted in the Jalpaiguri Medical College Hospital.
Yes, sir.
Charge sheet is pending, Lords.
Do you need custodial interrogation? Do you need custodial interrogation?
Yes, Lords.
Why? Why? If he cooperates, why? The petitioner says that there is a case and a counter case. Stop. The de facto complainant of this case tried to outrage the modesty of the petitioner's sister. Stop. This led to a scuffle. Stop. Both the petitioner and the victim got injured. Both the petitioner and the victim oblique de facto complainant got injured. Stop. The petitioner has also filed a criminal case against the de facto complainant of this case. Stop. He says that he will fully cooperate with the police. Stop. His custodial interrogation is not necessary. Stop. He prays for anticipatory bail. Paragraph. Learned state advocate, while opposing the prayer, shows me the injury report. Stop. He also shows me statements of witnesses recorded under section 161 CRP
180 BNS.
180 BNSs. Stop. Paragraph. I find that paragraph. Prima facie, it appears that there was a fight between the petitioner and the de facto complainant, and both got injured. Stop. On an overall assessment of the nature of the allegations and the material on record, I am of the view that immediate custodial interrogation of the petitioner may not be necessary so long as he fully cooperates with the investigating officer.
For your lordship. My lord, by the X-ray report, the audit,
X-ray report টা দিয়ে দাও। This is X-ray of your nose. নাকটা কিরম দেখি?
I'm for the statement.
For the petitioner. So matrimonial discord, lordship. The petitioner being the husband is before your lordship. The allegation is 498 and 307. His whole allegation is against the in-laws and the
Let us see.
In-laws and husband, injury is simple, lordship.
Simple injury.
Charge sheet
In-laws have been granted.
granted by the learned session judge.
Esho. Charge sheet.
not submitted.
Cooperate. They'll cooperate. The allegation against the husband and the parents-in-law are of torture and attempt to murder. Stop. The parents-in-law have been granted anticipatory bail. Anticipatory bail by the learned sessions court. Stop. This is the husband.
Lordship, husband is
The husband has now approached this court for pre-arrest bail. Stop. Paragraph. I have seen the statements of witnesses, including that of the victim lady. Stop. The allegations are general and omnibus. Stop. The injury report does not reveal anything significant. Stop. Paragraph. On an overall assessment of the material on record and the nature and extent and the material, overall assessment on record, I am of the view that immediate custodial interrogation of the petitioner may not be necessary so long as he extends full cooperation, charge sheet pending, you said,
Pending.
to the investigating officer.
My lord, I am for the petition. My lord, this petitioner is the mother-in-law. The case was started under 498 and 307 and other sections which are bailable. Apart from this mother-in-laws, other in-laws are granted bail with the learned sessions court. The allegation is that
Father-in-law has been granted anticipatory bail.
other except this mother-in-law. Others in-laws are granted bail, was the sister-in-law, brother-in-law, they are granted
Bail or anticipatory bail?
Anticipatory.
Yes.
The allegation is that there's by US strangulations, they are trying to kill. Including all these similar allegation is there. Facts is that your lordships on 27/12/2024, this lady, that is the de facto complaint, left her marital homes. So for the allegations made against that, they are made as strangulations. Medical report goes to suggest that is there any such injuries is there over.
Yes.
Lordship, the incident occurred within 1 year of marriage. This is the injury report.
It's the mother-in-law. 60 years of age.
Investigation is going on.
60 or 57?
Whatever.
Yes. What about the statement?
Lordship, the
She-
statement of the
It's against all the accused persons.
Lordship.
So nothing specific against the mother-in-law. That she tried
has come
to,
up in The statement of
has
the.
come up. The others' names have also come up.
Lordship.
They have been granted anticipatory bail. Esho. The petitioner is the mother-in-law of the victim lady. Stop. She says that she has no role to play in the alleged offense under sections 498 capital A oblique 307 IPC. Stop. All other accused persons, all other members of the petitioner's family have been granted anticipatory bail. Stop. She will cooperate with the police to the fullest extent. Stop. She prays for pre-arrest bail. Paragraph opposing the prayer, comma, learned state advocate shows me the injury report. Stop. Injury report and statements of witnesses, including that of the victim recorded under section
Once, 183.
183, mane 164,
161. 180, I apologize, Lord.
180 BNSs. Paragraph, I find that the injury is simple in nature. Stop. The allegations, the witnesses have made general and omnibus allegations against all the members of the petitioner's family. Stop. The other in-laws, meaning thereby the father-in-law, sisters-in-law, etc., have been granted anticipatory bail. Stop. The petitioner is a lady, comma, aged about 57 years. Paragraph, on an overall consideration of the facts and circumstances of the case and the material on record, I'm of the opinion that I'm inclined to allow the petitioner's prayer for anticipatory bail. So long as she fully cooperates with the investigating officer.
For the petitioner, my lord.
My lord, just now I received the CD, my lord. Not
Go
in a-
through it, go through it.
My lord, it's a voluminous CD, it will take some time.
Next circuit, what can be done?
But yesterday he filed.
I don't mind.
Yesterday he filed it. This-
On the learned state advocate says that he has just received the case diary. Stop. He shows me the case diary and it indeed is voluminous. Stop. He says that he will take some time to go through it. Stop. Paragraph as requested, comma, let this matter stand over and be listed before the next Yes.
Lordship, this is also an appeal against acquittal at the Narcotics Control Bureau, delayed by 194 days. So, my lord,
Special leave under 378 code. Why should we grant leave?
Special officer.
Yes.
but the appeal itself is delayed by 194 days.
Oh,
So, my lord, I am first to serve a notice upon
have
the,
you filed an application?
yes, my lord, CRAN is there.
CRAN 1.
Yes, my lord.
We correlate with the CRAN 1 type order for. This is an application for consideration of delay in presenting an appeal against an order of acquittal. So, let service of this application be effected on the respondents and the affidavit of service be filed in court on the next
Obliged, my lord.
paragraph. This is the matter before the next available service.
Obliged, my lord.
Sorry.
ভিডিও করবো
Lordship.
My lord-
Item 9, item 9. My lord, this is,
I am for the petitioner in item number 9 and the appellant.
my lord, in item 9, this is the application, my lord, of the learned, one of the joint
That's
special
all.
officers.
No matter. Yes, item 9.
Yes, my lord.
Yes,
I-
my lord, this is, my lord, this is the application of the learned joint special, one of the learned joint special officers, my lord. Mrs. Dhar Millard was appointed by Millard the learned single judge, along with Millard with Mr. Aman Gupta, Millard to take care of the Millard the petrol pump Millard in the meantime. Now, Millard, that order of learned single judge Millard is at page 10 of the application, and my lord will find Millard the relevant part appointing both of them at page 15.
Your lordship, I'm appearing for respondent number 6 and 7.
I'm for the petitioner in this matter.
Now, Millard,
Aman
this
Gupta
order
and
has
Ms. Dhar,
this is
joint special officers.
joint special officers. Now, Millard, this order has been upheld by your lordship by dismissing the appeal, Millard, on 12th of July, that is at page 17. Now, Millard, owing to her, Millard, personal difficulty and also, Millard, professional obligations back at Kolkata, Millard, she is an advocate from the principal bench of your lord, this honorable court. Millard, it's difficult for her to continue any further.
I have a
Millard, she had
vague,
indicated to the
I have a vague idea. You don't have to tell me.
And my lord, may I be permitted to,
Just the change of personnel, just the change of
Who-
personnel.
just the
Yes.
change of person. that's all,
2%
that's all, just
will
the
be
change.
changed, my lord.
Why,
May-
Mr. Aman Gupta
Yes.
also?
Yes,
Yes,
yes, my
Mr.
lord.
Aman Gupta has
Gupta
also
has
Millard,
also
written back 2 days
written.
back that
He is also Milord from Kolkata.
Kolkata.
My lord can appoint Milord my advocate on record there, Milord Mr. Dev, who is appearing. He is
And-
from a local, he is from the local bar.
And may I suggest one name from the local bar
Yes,
for in place of Aman Gupta?
Where is Mr. Aman Gupta's application?
Because we were to file the application for Aman Gupta. The application was ready, but in the meantime they have came with the application. But the application, if your lordship see that the who is making the application is not been clear there. The can has been filed.
The
Because
respondent number 8 to 9 to 11 are filing.
but
Because my lord will find at page 28, she has expressed her mind.
Mr. Rajgupta, this is a question of change of personnel.
That's
I
all.
don't
That's
think any formal application may not be necessary also.
Yes.
Huh?
Yes.
Acha, lekho. So Mr. Dipankar Dev in the place of Miss Priyanka Dhar.
and Mr. Sumit Kumar in place of Aman Gupta.
Sumit Kumar.
Sumit Kumar.
Okay. By an order dated June 1, 2023, passed in WPA 1206 of 2023, ব্র্যাকেটে শুভদীপ রয় পেজ 10 এ আছে দেখে নেবে বানানগুলো ঠিক থাকে versus State of West Bengal and others, comma, a learned judge of this court had appointed Mr. Aman Gupta, comma, learned advocate on record for the writ petitioner, and Miss Priyanka Dhar, comma, learned advocate for the respondent numbers 8 to 11 in the writ petition, comma, as joint special officers without any remuneration to run the petrol pump in question and the business thereof, and to keep a detailed account in that regard, and to furnish the detailed account in a sealed cover before the arbitral tribunal. Arbitral tribunal capital. Stop. Paragraph. The matter was carried in appeal by the writ petitioner by filing MAT number 72 of 2023. Stop. The appeal and the connected application were dismissed by a coordinate bench by a judgment and order dated July 12, 2023, comma, thereby affirming the the order of the learned single judge. Paragraph. The present application has been made on behalf of the respondent numbers 8 to 11 for change of personnel of special officer. Stop. Paragraph. Learned advocate for the applicants says that purely because of personal and family commitments, comma, it will not be possible for Miss Priyanka Dhar, comma, advocate, comma, to function as special officer. Stop. He has suggested the name of Mr. Dipankar Dev, comma, learned advocate on record for the respondent numbers 8 to 11 for being substituted in the place and stead of Ms. Priyanka Dhar. Stop. Paragraph. Learned advocate for the, you are for the appellant.
Appellant petitioner.
Appellant
Yes.
says that Mr. Aman Gupta may also be relieved from the duty of functioning as special officer and instead, comma, Mr.
Shumit Kumar.
Shumit Kumar, comma, learned advocate, be appointed. Stop. Paragraph. We see no reason not to allow the requests made, since we definitely will not insist on the present special officers continuing in spite of their personal difficulties. Paragraph, accordingly, comma, Ms. Priyanka Dhar and Mr. Aman Gupta, comma, learned advocates, comma, are relieved from the obligation of functioning as special officers, and in their place and stead, we appoint Mr. Dipankar Deb and Mr. Shumit Kumar, comma, learned advocates. Both of you are local here?
Local, they are the local.
Local,
Shumit-
local.
Learned advocates who practice in Jalpaiguri.
Jalpaiguri.
In Jalpaiguri.
Local.
Stop. The outgoing special officers shall hand over to the incoming special officers all documents and other material that may be in their possession within a week from date.
Deeply obliged.
Anything more, Mr. Dashgupta?
No, Milad, no.
My lord,
My
I
lord-
have a,
Oh,
I have a,
Mr. Mitra wants to speak.
Yes.
my lord, if your lordship kindly dispense with filing of accounts by the joint special officer.
My lord, because in the meantime, since 2023, no accounts has been submitted for running of the petrol pump. So we don't know what is the account still date, because it should be filed before the arbitral tribunal as per the order of the single bench, which was confirmed by.
We will only dispense with filing of accounts before us.
Yes.
Yes, yes. Before the arbitral tribunal.
We filing of accounts by the outgoing special officers before us is dispensed with. Stop. The accounts may be filed by the incoming special officers at the appropriate time before the arbitral tribunal.
Yes. Yes.
I am deeply obliged.
Oblige your lordship.
ওকালতম আমি জানি না ওটা কি
The-
এখানে নেবে না ডিপার্টমেন্টে বলে দাও না What shall we do with this file? Will it go back to the principal bench?
It should, my lord.
Yes.
My lord, it is the matter of the
It should. It
Jalpaiguri
should
bench.
go back. It should go back.
But it is a Jalpaiguri bench matter.
Yes,
right?
yes, my lord, because
No,
it was
Milad,
it was taken up
Milad,
on
the
the
next
date.
matter.
It was taken up
Milad, the
during the
next-
summer vacation in the principal bench, but it is a Jalpaiguri matter only.
Sir, at minute, sir. My lord, the next matter is a contempt of your lordship's order. It has to go back.
Which is
Milad,
pending.
because which is pending.
Anyway,
It's item number 10.
I think it should go back because we had called for it from Kolkata.
Go back.
Yes.
You
Yes,
know?
Kolkata.
Hello. File service of CAN application.
Yes, Milad, we have served Milad on all.
অ্যাফিডেভিট সার্ভিসটা একদম গোড়ায় নিয়ে নিও আর তারপরে লেখো তাহলে এই ক্যানটাকে ডিসপোজ অফ করে দাও না দি আদার পোর্শনস অফ দি আদার পোর্শনস এর কিছু নেই তো আর কিছু বলতে হবে না ক্যান ডিসপোজড অফ নেক্সট let the records be sent back to the principal bench at Kolkata.
My lord, deeply obliged.
Deeply obliged.
Mokalatnama filed on behalf of
The petitioner
appellant be kept with
appellant.
the records.
I am deeply obliged.
Next.
Grateful, my
I am deeply obliged.
Deeply. Grateful to you.
Yeah.
Your lordship, I am for appellant in this case. The
Why does it say defective? Anyway,
ultimately, I think defect has been cured. Uh,
yes, he has paid the dues.
But your lordship, on the last occasion, my learned friend has submitted a letter regarding no dues application, which was issued by the Employees Provident Fund. It is the letter of Employees Provident Fund. But there are other dues also, which is the ESI and gratuity. And it has been mentioned in my appeal, in my petition also, MAT petition, in page number 54, page number 59 and 66. Kindly have a look into page number 59. And the proceeding is going on before the labor court. Next date is fixed on, last date was fixed on 6th February 2025. There are other dues also.
Which is that clause on which you are relying?
Set of clause. Arbitration and set of, that is page number 22. Clause number 16. Moreover, on the first day, summarily it was rejected without giving an opportunity to submit any affidavit in opposition against that writ petition.
Summarily rejected.
Rejected without giving any opportunity to the
What was rejected?
The writ petition. It was the writ petition was rejected without giving an opportunity to the BSNL.
What are you saying, sir? Writ petition was rejected.
Your prayer,
Sorry. My prayer was.
Your prayer to file opposition.
My prayer to file opposition, my prayer to file affidavit in opposition was rejected.
This doesn't allow you to withhold this security deposit, this clause, sorry. This says, this is a set-off clause.
Yes.
Only if there are dues to you or somebody contracting with him through you. Please read the clause, sir.
Due and payable to the contractor.
May I read? Any sum of money due and payable to the contractor, including security deposit, refundable to him under this contract may be appropriated by the BSNL or any other person or persons contracting through the BSNL or such other person or persons for payment of a sum of money arising out of this made by the contractor with BSNL or such person or person contracting through BSNL. The second line is may be appropriated by the BSNL.
Sir, you have made your argument. Let us record our order. I am not able to explain to you. Correct.
There are dues to the other department also.
No, how this certificate officer.
Those departments have contracted with him through you.
They have issued letter to us.
Yes, that doesn't authorize you. Get a court order then. You cannot withhold his dues just because there's another claimant there. You are not their collecting agent. You cannot be. If something is due to you, yes, you can set that off. His money which is lying with you. But if something is due to X.
But as per clause 16.
You have not understood clause 16, sir. I'm sorry to say. issue.
And arbitration clause is also there.
That was argued, that has been rejected by learned single judge and rightly so. Now, learned counsel for the appellant today says that there are other dues on account of ESI and
ESI and a certificate officer and contractual laborers filed an application before the labor court. And certificate officer already issued notice upon the contractor.
আচ্ছা, এ করো তো, এভাবে বলো। That there are other statutory dues which the respondent firm has not paid. Stop. Hence, comma, the appellant is entitled to withhold his security deposit. Stop. Paragraph. Learned counsel relies on clause 16 of, what is this?
Contract agreement.
Of the agreement entered into by and between the parties. Stop. The said clause reads as follows. Running page 22. Mark করে দিচ্ছি। Page 16, huh? Paragraph. We are afraid that learned counsel has not been able to fully comprehend the meaning and purport of clause 16. Stop. That clause authorizes BSNL to withhold the security deposit made by the contractor only if there are dues from the contractor to BSNL or dues from the contractor to any person contracting with the contractor through BSNL. Am I right in understanding? No, no, no. No, set off will apply if something is due from you to him, and let's say somehow some money which belongs to you comes in their hand. They can set it off, adjust it. Yes, yes. Yes, what do you say? Oh, yes, yes, correct. Stop. Further, comma, the question of set off will arise only when BSNL has a claim against the contractor. Stop. BSNL cannot withhold the security deposit which is otherwise refundable to the contractor since the contractor has satisfactorily discharged his contractual obligations. Stop. If there are dues from the contractor to third parties, including statutory authorities, comma, that cannot be a ground for BSNL to withhold the security deposit. Stop. Paragraph, we see absolutely no infirmity in the order under appeal. Stop. The appeal and the application are accordingly dismissed.
Yeah.
Stop. Dismiss, that's all.
May I only waive the interest portion also?
No, no.
Only waive the interest.
Why?
portion.
Why? Misconceived appeal, a private contractor who has satisfactorily performed work for you. There's no dispute on that score. Why should we deprive him? The statutory corporations and public sector, I used to appear for them, so I know how they operate. Eight and you know.
My lord, may I recollect that the respondent was provided an opportunity by your lordship to bring sum of rupees 50 lakhs.
Oh, yes. Yes.
Very difficult, your lordship, but as due to yesterday, the entire financial institutions were closed.
Yeah.
I have, as of now, Your Honor, right now my client is at the bank itself. I have created a bank draft, but I could not produce the bank draft personally because it is not possible for him to send the bank draft in such short notice. I have taken the image of the same bank draft. I have made a bank draft of 30 lakhs. Your lordships, and 20 lakhs, I have prepared a check for them.
My lord, I again insist and iterate that he is not ready with the fund.
You are
He
the
doesn't have
appellant.
adequate fund.
You are the appellant.
I am for the appellant.
Your lordship,
He doesn't have adequate fund and he cannot. He is in fact negotiating with some other intending purchasers
that is the-
at a fantastic price.
Oof. You have come up against an additive. What is against the people?
Against an order.
Hmm. You are the plaintiff.
I'm the plaintiff.
I
And,
see.
one injunction, temporary injunction was granted in my favor.
Oh. Ah. তো bona fide দেখাতে পারিনি।
I have the bank draft.
What bank draft?
As for the order of your lordship,
What is it? That's a Xerox copy.
the bank draft cannot be, as all the financial institutions were closed yesterday. The matter was fixed day before yesterday, which was heard at 3:30.
গতকাল কি ব্যাংক ফ্যাংক বন্ধ ছিল নাকি মহাবুর জয়ন্তী?
NI Act, was it closed due to NI Act?
Yesterday was Mahavir Jayanti, all the bank financial institutions. were closed.
So we know state government offices were
State
closed.
government offices, bank
Yes.
Yesterday, day before yesterday was there.
closed, lordship, Mr.
Today it opens at 10.
That is the reason
Bank
why the
open-
bank draft has been created, but it has not been sent to me because it was created today. And in short notice, the bank draft cannot be sent to, I have the draft, photo of the same draft.
You next topic.
He's sending the same bank draft along with the check.
So on the 21st is the next circuit starts on the 21st of this month. You will be able to produce it, the bank draft?
Yes, bank draft, not check on that day.
As if 30 lakhs. bank
We'll
draft was
give
already-
them, sir, till 21st, a few days only.
Yes, my lord, he has been withholding the entire amount. It was supposed to be
Sir,
executed a year back, 1 year back. Then he has to pay the interest of 1 year.
that you make, that,
Prior to this, your lordship.
that make a prayer before the bench regarding interest.
Because it was supposed to be executed in the month of February 24, and this is June 25, 1 year, 1 crore 25 lakhs for 1 year, withholding this amount for 1 year.
Sir, we are trying to settle the matter
Yes,
for your benefit.
Settle the matter.
You get 1.25 crore, they say they are willing to pay.
Is-
That is the reason why.
they are entitled.
So.
Enough. Read order dated April 9, 2025, paragraph. देखिए Xerox টা দেখি। Learned,
Not being solved with the appeal act. I've
Well,
only
the
been
intending
solved with the
purchaser.
can act.
learned advocate for, this is
There are 3 pages prior, 3 pages after that.
10
Let me
lakh.
see the copy, it's not clear. But then. What about it?
3 bank drafts of 10 lakh each. And
We said 50 lakh.
Why 50, why?
10 lakhs of
Check, we didn't, check will not do.
First short notice, my client is.
No, on 21st you produce 50 lakh bank draft.
Yes, no check on that day.
কি বললো? For the respondent produces
Lord, I'll go on suffering.
Xerox copies, then we will say nothing. We are trying to help you. If you are,
Waited so long, just wait for 7 or 8 days.
কি বললাম? হ্যাঁ, Xerox copies of 3 bank drafts of rupees 10 lakh each and 2 checks of rupees 10 lakh each. Stop. He says that yesterday was a bank holiday because of Mahavir Jayanti. Stop. There was not sufficient time to arrange for bank draft of 50 lakh. Stop. Further, the originals are with his client and he has not been able to collect the same before coming to court today. Paragraph on the request made by learned advocate for the respondent, let this matter be listed before the next circuit bench on April 22, 21st it starts.
21st.
April 22, 2025. 25. Stop. On that date, the respondent shall positively produce bank draft of rupees 50 lakh to show his bona fides. Stop. In the event the respondent does not do so, the interim order that he has obtained in the suit filed by him before the learned trial court may be liable to be vacated.
You see, you will get 2 more days. Don't take that plea because there are 3 days holiday. You're getting 2 days in the meeting.
The record.
So again, don't come.
As I stated on the last day.
No. Next week is also there are holidays.
Copy.
All right.
Grateful one humble indulgence. The main appeal application has not been served to me. I have been served with only the CAN application. By the applicant.
Give him.
Anyway, it's all right.
He is giving you bank draft, giving an application.
Grateful.
Respondent.
Appellant is not here. The appellant is not represented. Appellants are not represented. Stop. Today is the last day of this circuit. Paragraph. List the matter before the next available circuit bench. Hey.
I am for the appellant in this matter.
Yes.
Lordship, this is an appeal against the suit for partition was dismissed by the trial court, and the honorable court was pleased to grant interim protection on 2nd April in this matter, for which is operating till today and expiring today itself. Lordship, it needs to be extended.
We'll extend for a limited time period, place it before the next circuit.
Lordship, respondents have appeared on the last day.
You are for all the respondents? Oh, now that they are appearing, no problem. Oh, status quo. Let the interim order that was passed on, the interim order of status quo that was passed on April 2, 2025, continue till the last day of the next circuit or until further order, whichever is earlier. Paragraph. List the matter before the next circuit bench.
Grateful.
Next available circuit bench. No. Next matter is the last circuit.
My lord, I am on behalf of the applicant.
I am appealing for the respondent husband. Lordship. Respondent husband, Lordship.
Yes.
files an application to stay the impugned judgment, my lord, of the divorce, my lord. A stay application is there, you can sue.
Lordship, in this regard, we would like to file
Why
an
should we stay
opposition.
the judgment? It was not a contested.
It was a contested. And the wife in her written statement as well as in evidence in chief, she herself claimed that she wants the dissolution of the marriage.
No alimony was decided in the instant case. And most importantly, my lord, the husband is required to prove his case on his own footing, not on the stand of the wife, my lord. The
Wife has admitted that she wants
your
to.
lordship sees
If
the
your lordship kindly
the
text up the
judgment of
written
the
statement.
divorce case, my lord. It is.
If your lordship kindly text up the written statement, the
wife-
prayer in the written statement, first
Hey,
prayer.
Hindu marriage act দাও তো Hindu marriage act দাও তো
So wife was the petitioner before the trial court.
না না
No, responded.
No.
Yes. So
Huh.
why you say wife has filed the case?
No, wife, no, he has written the judgment in that manner.
হ্যাঁ দাও দাও ওটা তো
Paragraph number 6.
where is the annex the judgment?
Yes, ma'am. The main FAQ, ma'am. Page number 6 of the judgment. The husband has come with two pleas. One is cruelty, another is desertion. The wife never said that she has left the company of the husband.
No, she has stated on doc that there is no chance of reconciliation.
Yes.
Question which was asked, my lord. But the husband has to prove his case, my lord, on the
Now,
ground of
now
cruelty.
are you willing to reside with your husband?
And she is residing in there only, in her husband's house only.
No, no, no.
And
That is
my
not
lord,
the situation.
And if your lordship can sees the can 2 application, there is an eviction letter which has been given to the wife to evict the house, my lord. And that is why I wanted to stay the order, my lord.
Oh, at present, if you are ready and willing to reconcile, I can ask your learned friend to consider.
My lord, they will not. We have already, my lord. The husband wants to
She
marry
herself
again, my
has
lord.
stated that she wants to dissolve the
husband wants
marriage.
to marry
Kindly
again.
see her written statement, lordship. Kindly see her.
Anyway, we are not deciding the appeal because we don't have the time.
Lordship, we will be filing a short opposition, lordship. Kindly grant us that liberty. We want to file an opposition to the stay
Yes,
application.
But you don't marry in the meantime.
He's 50 years old.
That protection you have under section 15.
There's a statutory protection.
Yes.
সেটা আমরা clarify করে দিচ্ছি।
That provision should be complied.
He has a son, my lord. He has a son also, my lord. The son is with the mother only.
এসো
No. Son is staying in Chennai for his.
Studying.
আরে বাবা দূর This is an appeal against a judgment and order dated July 26, 2024, passed by the Additional District and Sessions Judge, First Court, Darjeeling, in Mat Suit 61 of 2022, whereby, the respondents' suit for divorce has been decreed by the learned trial court. Stop. The wife has come up in appeal. Paragraph. What is your can? Stay, I see.
Stay.
He wants to file an opposition. You want to file an opposition to the stay?
Lordship, to this.
Stop. Let affidavit in opposition to the stay petition be filed within 2 weeks from date.
Lordship, grateful.
Reply thereto, if any be filed within a week thereafter. Stop. Paragraph. List this matter before the available circuit bench after 3 weeks. Next.
In the meantime, lawyers could see that it is reconciled.
They will not, my lord. They will not. He is interested in married again.
Keeping in mind the provisions of section 15. Section 15 of the Hindu Marriage Act 1955 reads as follows. Paragraph, in view of the aforesaid, the parties, both parties, are restrained from remarrying till disposal of the appeal. Age of Section 15. Chalo. That is enough for this circuit.
Lordship. Good.
বেশি দিনই তোমাদের হয়ে যাবে, ফটাফট টাইপ করে দিয়ে দাও।
এগুলো সময় আছে, দুটো তো বাজে।
Thank you.